Good afternoon, everyone, and thank you all for attending this afternoon's webinar which is part of our new series on the Assisted Decision-Making Capacity Act from legislation to practice. We've got many people joining us today, so we're just about to kick off. My name is Caoimhe Gleeson, and I manage the HSE National Office for Human Rights and Equality Policy. Today's topic is on decision-making representatives, and we've got quite a number of people contributing to today's presentation or today's webinar. We have Áine Flynn from the Decision Support Service, who's joined by a number of colleagues from the Decision Support Service who will be able to take questions and will be able to take questions during the presentation itself. We have Peadar Brown, who is a solicitor with the Legal Aid Board, Susie Byrne, who is a regional advocate from the National Advocacy Service for People with Disabilities, Ultan Hines and Louise from the Nursing Home Support Scheme, and then Sarah Whelan, who is a panel decision-making representative. The question and answer function is open. Please ask questions as the webinar is progressing. And as I said, we have a number of people who will be able to reply to you and will be able to address some of the questions in the Q&A function. We also will be able to address some of your questions live. Furthermore, we also had a number of questions that were submitted to us prior to the presentation, prior to today's webinar, so we'll be able to try and get to some of those as well. The webinar will be recorded and you will be able to access the recording from our YouTube channel. We will put up the link in the chat throughout the webinar. You can also access our previous webinars from that YouTube channel. I also recorded a separate recording with Judge John O'Connor who's a judge of the Circuit Court in Dublin, and this will also be available as an additional recording to this webinar once this webinar has been concluded. I'd like to thank and welcome Lisa and Romy, who are our ISL interpreters. If you wish to have a certificate of attendance, there will be a QR code for you to scan at the end of the webinar, and we'll make announcements about that. In terms of CPD, this webinar is worth 2 CPD points pending approval from the RCPI. So without further ado, I want to hand you over now to Áine Flynn, who's going to talk through particular issues that relate to decision-making representatives. And also just to say, Áine is joined by a number of colleagues, Kate Fruin, Joanna Macklin, Aoife McManus, and Patsy Fitzsimons, who are available in the background, who will be able to take questions as well. So without further ado, I'm going to hand you over to Áine. Thank you.
All right, thanks very much for the invitation to be here today, and joined by colleagues, as you've heard, from registration, supervision panels and complaints in the DSS, because the functions of a decision-making representative can engage with all of those divisions of the DSS. My slides probably take more than 25 minutes if I were to go through them in detail, but I hope that the information which they contain is useful to you. I will be going through them somewhat speaking to rather than from them. But starting first of all with, and I'm sure many of you are familiar with this content, how a decision-making representative or DMR comes to be in place. That can be an outcome of Part 6 and the discharge from wardship of people who are wards of court. That process is continuous, and timelines were recently extended to the 25th of October of next year. The legislation got amended to allow that to happen. That's a process managed by the court. So too are Part 5 applications to the Circuit Court, and those are applications which may be brought by any person with a bona fide interest in the welfare of the relevant person. So as stated, the DSS does not process, and we are not directly involved in these applications to court. And I've included links here, and I've put links throughout this presentation, and also at the end here we have links to the court service information about both the Part 6 ex-wardship process and the Part 5 applications to the Circuit Court. So as an outcome of either of those processes, the court may make a declaration that the relevant person lacks capacity even with a co-decision maker, because the court must always think about the least restrictive thing to do, and may therefore either make a decision-making order, rare to none, I believe, or a decision-making representation order, which we'll be calling a DMRO, appointing a DMR. So that capacity declaration made by the court, which is the foundation of the DMRO, has to be reviewed every 12 months or 36 months at the latest if capacity isn't going to change. Those are Section 49 reviews. I'll return to those under the duties of the DMR. So in making the DMRO, the court has to think about certain matters, including, and these really go to the suitability, an important word, the suitability of the DMR. So the court must exercise the guiding principles under the Act. The court must think about the will and preferences of the person. The court must think about existing family relationships, the desirability of preserving those relationships, any potential conflicts of interest, and also think about the complexity of the decisions and the expertise that's going to be available to any proposed DMR. And then where there is no suitable willing DMR, the court may turn to the DSS to ask for nominations from our panel, and I'll speak more about the panel a few slides from now. I've just mentioned here a couple of pieces of relevant case law when it comes to suitability or calls upon the DSS panel. The first is a decision from Judge O'Connor from quite early on in the lifetime of the Act, where there was a very complex family dynamic at work, and ultimately a DMR from the panel was appointed, and a much more recent judgment which happened on appeal to the High Court. There haven't been very many of these, but it was an appeal from the Circuit Court to the High Court taken by two family members belonging to the relevant person who had been, if you like, passed over by the judge who was looking to nominate, to appoint from the DSS panel instead, and that was effectively reversed in the High Court on appeal. All of these considerations around suitability and how to work through making a DMRO apply equally to Part 6. So there's a section which says everything that the court, the Circuit Court can do, the Wardship Court, primarily the High Court, should also be doing when it thinks about making DMROs. I always say the Wardship Court rather than the High Court. There is just a handful of Circuit Court wards, and they are also coming out under Part 6, and that's happening in the Circuit Court. An important section perhaps for this audience, under Court 50, the court may seek other expert reports to help in its deliberations, and I think that's often helpful, so that a court looking at family member applicants about an RP who's in a service may say, well, let's hear from the service. What does the service think about this person's capacity or the suitability of any proposed DMR? When appointing, if appointing more than one, the court must state whether the DMRs are to act jointly, always as a unit, or jointly and severally, potentially independently of each other. And then the order is sent to us. So the DSS may have had nothing to do with this entire process, except possibly being asked to nominate from our panel. We come in at the end when a DMRO is sent to us for registration and supervision, and that doesn't always happen right away. This order has to be perfected in the court office. That describes the process where it's tidied up and a signature applied to the end of it, and then it gets sent to us. Important to say that a DMR becomes a DMR on appointment by the court, not on registration by the DSS. We're putting in a searchable register, but we're not working any kind of extra magic. You're a DMR because the court said so. A busy slide, but let's just go through some of this. So the duties and functions of a DMR are set by the legislation and also by the individual order appointing them. Their job under the Act is to find out about the person's will and preferences and help them to communicate their will and preferences, making decisions then on behalf of and acting as agent for the relevant person. And then there's a particular section where if the court had really wanted to appoint a co-decision maker, but none was available or a co-decision making agreement didn't happen, then that sort of DMR has to try as far as possible to make decisions jointly. They're very likely to be a panel DMR. They have to have regard to the codes of practice, which the DSS has published, and they sign up to all of this in court, signing a statement saying that they understand that they're going to act in accordance with the duties conferred on them by the court, and that they are particularly familiar with the guiding principles and going to act in accordance with them. There's some things that a DMR may never do. They can't stop a person from having contact with the relevant person. They must confine themselves to what is specified for them to do in the DMR. There is a particular exclusion around what they can do in relation to trusts without the court's approval, and they never make decisions about life-sustaining treatment. If they're going to make gifts, that has to be particularly spelled out in the order in the DMRO. And any provision for restraint, which appeared in the original version of the Act in 2015, that was deleted when the Act was amended 4 years ago in 2022. Relevant decision is an important phrase, and it's defined in the Act. Effectively, it's a decision taken by a DMR which is in scope of a DMRO. Guiding principles, this slide will be familiar to many of you. Let's just look at a few of them. They're, as I've said, giving effect to will and preferences, acting in good faith and for the benefit, doing the least restrictive thing, and perhaps importantly, as an intervener, the DMR may consider the views of any person involved in care of the relevant person, any other person who has a bona fide interest in the relevant person, and healthcare professionals. And they must use their information appropriately in the context of making relevant decisions. There's a code of practice for decision-making representatives, codes of the particular status provided for in the Act, that if you're doing a function in respect of which a code provides guidance, then you must have regard to the code, and they're there on our website with other materials and resources. Sometimes after a DMRO is made, a further application to court is necessitated sooner or sometimes later, because DMROs can be varied and they can be discharged, and any person entitled to apply to court in the first place is entitled to go back under 3814 if there's a perception that the DMR needs to be able to do something else, or in fact to seek the removal of the DMR. Additional clarification may be required. Sometimes, and we have seen this, DMR is applied to come out of being a DMR. Nobody else but the court can unappoint them. We don't bring those applications for the DMR, and we publish some practical guidance which is available on the website. I think I have a link to it at the end. I'd alluded briefly earlier to the Section 49 review. So after making the declaration in relation to capacity, a further review of that capacity has to be undertaken by the court. Actually, the relevant person or other specified parties may go in at any time seeking a review of the declaration in relation to capacity. But in every case, the court has to provide for a review within 12 months or 36 months at the latest if the view is that capacity isn't going to change. The Circuit Court reviews the capacity declarations made by the Wardship Court. The Wardship Court's function is spent, and after all, the Wardship Court will be finished looking after adults by October of next year. One thing the DMR has to do is take up an updated capacity assessment. That's something which the court rules have said that particular job falls to the DMR. And it's not a review of the DMR's performance, the performance of the order, but sometimes the opportunity is taken at that review hearing to amend and make other perhaps changes to that order. So moving on to the panel. Section 101 of the Act says that we will establish a panel of suitable, that word again, persons willing and able to act as DMRs who are available to be nominated to the Circuit Court or the Wardship Court. And we have done 3 phases of recruitment. As part of that, we meet with all DMR candidates. They're all interviewed, and that's done in a competency framework. There are certain credentials that we require from all of them, that they are professionally registered as a matter of law, academic qualifications, Garda clearance, obviously. They must carry professional indemnity insurance covering their role as a DMR, and they attend mandatory training comprising 17 quite diverse modules. They are not ours, if you like, in the DSS, not our employees, they're not contractors of the DSS, they are suitable persons whose names are on a panel and who have fulfilled these selection requirements and keep their credentials up to date. If a DMR is a solicitor, they haven't become the relevant person's solicitor. They haven't become their social worker, if that's their professional background. They have become their DMR. And the functions and duties of a panel DMR are identical to those of a non-panel DMR. We operate the panel on a rotational basis per court area and have figured out a process for communication of these requests with the court's service. Panel DMRs may be remunerated. The court determines whether we, the DSS, are paying them, or whether that payment is out of the court's assets out of the RP's, the relevant person's assets, and remuneration is set by regulation. Here is an overview of the membership of the panel. So you can see that legal and social work account for the primary professions represented in our latest recruitment. Social care workers also having become Carew registered were eligible for appointment. So we foresee having 160 after a new 50 or so are admitted to the panel in the coming weeks and months. We are experiencing an increase in requests from the Wardship Court as the rate of discharge applications increases. 599 panel members have been appointed ever since commencement, accounting for about 25% of all DMROs. But here are some more statistics for you, so that we have registered ever just over 2,500 DMROs, and I have here the breakdown from the Circuit Court and the Wardship Court. Currently about, 1,900 approximately DMROs are active, as orders may come to an end due to discharge, expiry of the function for which the DMRO was made, or in some cases, sadly, the relevant person has died. And we will always have more active DMRs than active orders, bearing in mind that a DMRO may appoint more than one decision-making representative. That's true in about 550 cases at the moment. We publish all of our stats, incidentally. There's a link there every month on the DSS website. So you'll find registration updates about all of the decision support arrangements that are registered with us. And there's another way of showing how we have been busiest, but it's changing with requests, with DMROs sent to us from the Circuit Court, but obviously an acceleration from the Wardship Court. And there, just for interest, is the age profile. So it looks like the biggest age category being relevant persons aged in their 80s. So supervision of DMRs. This is a function of ours. We supervise decision supporters under the Act, and DMRs have particular reporting duties. They turn in an annual report to us, and if they've been appointed to property and affairs decisions, they have to come to us within 3 months of appointment with a statement of assets, liabilities, income and expenditure, thereafter keeping their accounts and records and making those available to us for inspection. If they're late, if they're incomplete, we engage. We would only go back to court as a last resort, and I believe we've only had to do so once where reporting was deficient. So here's a summary, I guess, of matters arising from our perspective in terms of registering and supervising decision-making representation orders. We will always provide information. We're tasked with doing that, again, under Section 95, but we don't provide legal advice to a DMR. Coming to us, we see these are orders which are increasingly using standardized templates, wording about bank accounts. That's welcome because banks like precision, but not always. The orders don't always look like the same thing. This is rare, but occasionally we see items which are actually outside of scope of the Act. There was one which looked as if it was conferring authority in respect of life-sustaining treatment, or I'm recalling one or two which looked as if the role of the DMR might survive after the death of the RP, which couldn't be correct. Section 138, a section of the Act, says that here is a list of matters in which you couldn't have somebody deciding with you or for you. We've published an information note and there is a link to it. So we see this arising a bit, it's not frequent, but in relation to family law proceedings, because the pre-existing law on divorce and separation still applies. So it seems to us you couldn't have a DMR deciding for you that you're getting divorced, but how far can they be involved in divorce proceedings and the matters associated with divorce around property and so on? Our information note might help. We will say if we think that something is in scope, something that a DMR proposes to do. And DMRO's orders can be very directive, telling the DMR to do this, 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 and this, list A to K. But sometimes they're granting a broader authority. Definitely a variation between Part 5 Circuit Court and Part 6 Wardship Court as far as that goes. We encourage DMRs to communicate their authority, make sure that those who need to know that they are DMRs are kept informed. Sometimes they need to take other specialist advice. They report to us issues with delays in the perfection of orders, which means that they've no proof that they've authority to act. If you see, I've said already that you're a DMR when the court says so, but if you don't hold that court order, and we've never seen it, it hasn't come to us yet for registration, then you're obviously at a disadvantage trying to introduce yourself to the services that need to know that you are the DMR and to do the job that the court has appointed you to do. Sometimes things will come up where the DMR is in all conscience saying, I don't think I'm authorised to do that and need to reapply to court. I'm recalling an example where quite early on, the order said that the DMR was authorised to find a suitable nursing home, but it didn't take the further step of saying, and then to sign the contract to access the funding. And that DMR, who was a panel DMR, had to go back to court seeking a variation and expansion of role. I've alluded to broadly worded orders. They can present challenges if they appear to confer unlimited scope. I've mentioned here a High Court judgment from late last year, which engages with the fact that orders from the Wardship Court may sometimes be broader in their terms. Sometimes DMRs will report a difficulty in the engagement with families or other third parties. Sometimes families thinking that the DMR has to provide very frequent updates and consult with them extensively, which is not actually what the Act requires. Or sometimes there can be a frank failure to understand what the DMR is there to do. We would tend not to directly intervene with that third party, but to try to equip the DMR to be able to have those conversations and prove that they're allowed to do what they are purporting to do. Not all banks and other financial service providers read the role of the DMR or the orders in the same way. We work with those services to try and improve understanding. Sometimes there's an overseas aspect to it, and that can present other challenges. Sometimes a DMR has to bring litigation separately because an issue has arisen, and accessing legal aid is not always straightforward. There's that duty to take up the updated capacity assessment and go back to court for the review. And occasionally, you could be, as a DMR, looking after a relevant person who's the subject of separate orders in inherent jurisdiction, and they may not always interface smoothly. So our register is searchable. Many HSE organisations, 55 HSE organisations out of a total of 76 in health and social care, being bodies prescribed by regulation, are set up to search the register without having to go through us every time, if you like, and some professionals also, including healthcare workers. Aoife has provided links here to how to access the register and find out about being set up, and we turn those requests around swiftly. Most common searches are by the HSE, in fact, and relate to either DMROs or enduring powers of attorney. And if you're expecting, I'll just mention this again, to do with delayed orders, to see an order there and it isn't there, and if it's Part 6, it might be best to contact the Office of Wards of Court first. We may not know about it either. Complaints about DMRs may be taken on particular grounds, which I have mentioned here, mostly to do with acting outside of scope of function, outside of the Act, outside of the order, or having become again unsuitable, which has that meaning mostly looked at by the court when they appoint you under Section 38.5. And these are our powers to take up information, to engage, to summons witnesses, if necessary, to apply to court while the investigation is ongoing, to suspend a DMR from acting. We've done that once only. And there are a few limitations with the Act in that it's only after we find a complaint well-founded that we can then try to resolve informally or even provide clarification. And when that doesn't work, we would be applying to court for their potential, for the court's consideration about what should happen next. Complaints may be processed in these ways, directly with us on a complaint form, and our processes are published. And here are some statistics in relation to all of our complaints. We've had 202 in total, of which 72 related to DMRs. The referrals to court are few, however, we do, and only a minority, I think overall, have been found to be well-founded. Some issues arising in relation to complaints. They're managed in quite a formal way. So if you wish to bring a matter to our attention, a concern, trying to get hold of a DMR, whatever it might be, going the complaint route does put you in quite a formal path. We have 9 months to process a complaint. We will engage with the complainant. We have that limitation about only being able to resolve informally after we find complaints well founded. So perhaps a call to supervision might actually get you a quicker outcome. And finally, let me mention some resources which we have, and I hope that these links are useful. So there are the codes, an introductory leaflet on the reporting requirements. At the start, DMRs were sometimes taken by surprise by the extent of their obligations to the DSS. We have template reports as well and guidance associated with those. Also information on how to claim expenses and remuneration if you're entitled to them, information on discharge. And then this has been a leaflet which we've developed lately. When a panel DMR is appointed, what to anticipate if you're somebody close to the person, and what you can expect in terms of engagement with that panel member. And then information on investing, which is sometimes of particular interest to families of those people coming out of wardship who may have very significant resources. Caoimhe, there, I will stop on time, I think, and happy to take questions after this. Thank you very much.
Thank you, Anya. That was really comprehensive, and I know we've many questions already answered in the questions function. Okay, so we're going to move on now to Peadar Brown, who's a solicitor with the Legal Aid Board. Peadar has direct experience of supporting relevant persons through the application process, through the court process, and we'll talk about those experiences as well. So thank you, Peadar.
So I'm Peadar Brown, the Managing Solicitor of the Dublin Assisted Decision Making Service of the Legal Aid Board. And I'm speaking to you today just generally about the Legal Aid Board's role in Part 5 applications. The board provides services to applicants under every part of the Act that's set out there on the slide. But today I'm speaking just about Part 5 applications. So the type of applications that we receive in relation to Part 5 are those listed from numbers 2 to 5 there. Obviously, ex parte applications are made by an applicant without notice to anybody else. Once consent is granted to an applicant, then they'll bring a substantive application. Other people who are prescribed under the Act to bring applications without the court's consent will start at the substantive application. We can provide legal aid to any applicant who qualifies for legal aid, and I'll speak about that in a moment, to bring a Part 5 application. We can also provide legal aid for anybody who's bringing a notice of motion, whether it's to vary an order or for new reliefs. And we can provide legal aid to relevant persons in relation to reviews of capacity, and also to lay people who might be, well, it'll be a DMR, possibly a family member, who's seeking to have a declaration of capacity reviewed. So, as I said, who may apply for legal aid? Any family member, any individual who wishes to bring an application or who is seeking to have legal representation for the relevant person under Part 5 application. All applicants must be natural persons. We cannot accept applications for person for independent legal advice can be accepted from a natural person working in a body corporate, such as a social worker working in the HSE. However, it's only in applications for independent legal advice for a relevant person regarding either substantive application, notice of motion, or capacity review that legal aid is provided free. In all other cases, applicants must undergo a means test and a merits test, which I'll explain now. The means test obviously is, as it sounds, a person's income is assessed to see whether or not they are eligible for legal aid. Currently, the test is that an applicant must have an annual disposable income of less than €18,000. That sounds particularly small, but there are certain allowances allowed against that. And also disposable assets of less than €100,000. An applicant's family home is not included when calculating assets, and the other allowances for certain expenses include things like mortgage or rent being paid, whether maintenance is being paid, the number of children a person might have, and there's an allowance for a person's spouse if they're married. So an applicant who is deemed eligible for legal aid will be asked to pay a contribution. These are usually very modest. They rarely exceed a few €100. If a person finds himself in a difficult situation and is unable to pay the contribution, they're entitled to seek a full or partial waiver of the required contribution. Waivers are granted at the discretion of the Legal Aid Board, having considered the circumstances that are put forward by the applicant. Apologies. So the merits test is a separate matter, and as it sounds, it's a test of the merit of bringing an application. The board will consider whether an average person will be willing to go to court if they were paying for that themselves, and it will also consider whether a solicitor or barrister acting reasonably will recommend that an applicant go to court, knowing that they were paying for it themselves and based on the fact of the case. The board may also examine other factors, such as whether the applicant has grounds for taking the case or defending the case that the other person is bringing against them, if bringing a case is the best way of resolving a dispute, whether the applicant would be likely to win the case, and the cost to the taxpayer of the benefit to the applicant if they win. Now, obviously, in assisted decision-making, these tend not to be adversarial matters, so the notions of winning or losing a case tend not to apply. So applications for legal aid must include a legal aid application form. Many applications come to us without that form, and it is an essential requirement. If the application is for independent legal representation for a relevant person, the application form should be completed in the name of and with the details of the relevant person, but can be signed by a third party if the relevant person is unable to sign. Financial details are not required at the moment. There was a provision for costs to be recovered post cases in assisted decision-making matters, but the regulation required for that to be implemented is not in place. So at the moment, there is no requirement for financial information when applying for independent legal representation for a relevant person. The application form should be accompanied by copies of the forms 55A, B, and I, which is the grounding affidavit, to include any functional capacity assessment being relied upon. Application forms can be downloaded from our website, and there's also an online application form at the link shown there. On this slide are the contact details for my unit, which is the Ballymun Law Centre. There's an email address there and contact telephone number. So why is a solicitor required for a relevant person when it's not prescribed by the Act? The answer to that lies in the two judgments often recited in the Circuit Court, which is in the matter of KK, where Justice Niamh Hyland averred that there should be independent representation for the relevant person, and also in the matter of AC and others versus Cork University Hospital, where Justice Sultan Mali had the same view. So that's why a solicitor is required for the relevant person in every case. There are three proofs usually required by the Circuit Court when bringing an application under Part 5. One, obviously, is the functional capacity assessment, and that's usually required to be in the form of a template that was designed by Dr. Sean O'Keefe. A copy of that template is available from various sources, including the HSE's website at the link provided. The second proof is the presence in court of the relevant person, as the hearing shall be in the presence of the relevant person, as provided by Section 139 of the Act. If the relevant person cannot attend, the court will require a report from an advocate. Usually when we're dealing with elderly people, that's provided by Sage Advocacy, and for younger people, usually the National Advocacy Service provide those reports. The third proof then is independent legal representation, where a legal aid board solicitor will visit with and consult with the relevant person, try to explain the nature of the application to the relevant person and canvass their views or their will and preference in relation to the application and report that back to the court. So the legal aid board solicitor provides that advice in all types of applications to the Circuit Court under Part 5. We have 34 law centres countrywide, so the country is well serviced and every jurisdiction has a law centre nearby. Legal aid will either be provided in-house by legal aid board solicitors or by private practitioners who are on the Legal Aid Board's panel of private practitioners, and there are a great number of those countrywide. The panel, the PP panel for work under the Act is comprised of private practitioners in every court jurisdiction. For matters that are not dealt with in-house, an applicant on behalf of the relevant person may choose a private practitioner from the panel. Oftentimes, there is nobody to make that choice, and the board will select a panel solicitor randomly to represent the relevant person. So what is the role of the Legal Aid Board solicitor? As I had said, it's to provide advice to the relevant person and canvass their views in relation to the application before the court. The court considers that role of the Legal Aid Board solicitor to be different from that of an advocate, whereas the advocate's role is in providing the voice of the relevant person, whereas the Legal Aid Board solicitor is providing legal advice and canvassing the views of the relevant person. So we visit the relevant person at home or in a hospital or residential setting, explain the nature and purpose of the application, and record the relevant person's responses. The court also expects the solicitor to be aware of the assets of the relevant person and to protect those assets from potential conflicts. Conflicts are common in Part 5 applications and may manifest in the form of an applicant living rent-free in a relevant person's house or paying bills with the relevant person's monies for services for which the applicant is benefiting, to more sinister abuses of the relevant person's assets. The solicitor will also engage with lay applicants or solicitors for applicants in a collaborative manner. The court is always stating that these matters are not adversarial, but more collaborative and inquisitorial. Often an applicant might be in a hospital, will be a hospital in which a relevant person is a patient. The relevant person may have no family member, and a DMO needs to be appointed so that the relevant person can be discharged from a hospital to a step-down facility or a nursing home. The solicitor may liaise with members of a multidisciplinary team, such as social worker or speech and language therapist, at the hospital to obtain additional information about the relevant person. Solicitor may also liaise with other service providers or perhaps family friends to establish a holistic picture of who the relevant person is. The court expects the Legal Aid Board solicitor to have that holistic view and to liaise with third parties to provide that. The Legal Aid Board solicitor will often be aware of the nature of the title of the relevant person's property to ensure there is no conflict or imperfection in the ownership of the title. And this can be very useful where applications are being made for the fair deal. So the scope of legal aid, this is similar to the first slide. It sets out the various parts of the Act under which we provide services. Legal aid relates to representation in court, whereas legal advice relates to matters that do not require court representation. So, for instance, with a co-decision-making agreement or a decision-making agreement, we provide legal advice, whereas with a Part 6 discharge application or a Part 5 application for a DMRO, you're receiving legal aid. So certain orders can be made under the Act giving a DMR authority to carry out certain actions on behalf of a relevant person which are not governed by the Act. Examples of those include authority to bring ejectment proceedings against a person or persons occupying a relevant person's property without consent. There's been quite a number of those applications received by the board. And authority to bring or continue family law proceedings. We've received one of those most recently, and I note that Anya referred to some of the limitations that might surround a DMR acting in family law proceedings. So that's a very novel area and one where there may be significant limitations in DMR acting. So the authority provided by these orders does not automatically confer a right to legal aid. In these circumstances, the DMR must make an application for legal aid to the board. The order must state that the DMR has authority to bring the particular application, and then that application will be subject to a means and merits test. So issues and trends. Currently, obviously the Act is still evolving even 3 years after it was commenced, and there are a high percentage of lay applicants compared to other legal practice areas in civil and family law. This has given rise to a commensurate high percentage of adjournments in applications before the court, as lay applicants often do not have the required proofs in order and must receive directions from the court, and often assistance from Legal Aid Board solicitors representing the relevant person to bring those proofs up to the standard required by the court, which indicates the collaborative nature of the applications. The most common issues lay applicants encounter relate to the standard of the functional capacity statement that's provided and the drafting of affidavits and proper service of those on the relevant person and other notice parties. There are also a number of lacunas in the circuit court rules that lead to issues arising. The most common of these relates to the fact that the Act doesn't provide for independent legal representation for the relevant person. As this wasn't envisaged from the outset, There's no mechanism in the court procedure for the relevant person's independent solicitor to come on record, so we don't file an appearance. And therefore, there's no provision for the service of documents or interlocutory applications on the relevant person's solicitors. Matters often appear in the assisted decision-making lists, which the Legal Aid Board solicitor has no knowledge of. Similarly, notices of capacity reviews, whether they be the statutory review or a review brought by a third party, are issued only to the DMR or other notice parties, not to the relevant person's solicitor. This leads to there being no representation for the relevant person at the initial listing of the capacity review. Similar to there being no requirement under the Act for the relevant person to have an independent solicitor at a substantive application, there's no requirement in the Act for the relevant person to have a solicitor at a review, and it's questionable or not whether this is required considering a declaration of capacity has already been made. And that's what I've just mentioned there. So the review usually takes place when a declaration has already been made under Section 37(1)(b) that the relevant person lacks capacity. Finally, a significant issue for petitioners is a lack of consistency between different circuit court jurisdictions and even between different circuit court judges regarding the standard of proofs required by the court. And it's my own view that this practice area would benefit from a practice direction harmonising the procedures in and the requirements of the court. A couple of other trends which I'd like to mention relate to something Anya touched upon, which is that the orders made in Part 6 discharges appointing a DMR tend to be quite broad, and many DMRs are coming back into the circuit court looking for variations of those orders under Section 3814. There is also an increase in the number of applications coming in determining whether or not a relevant person has litigation capacity, and that's usually so that personal injury action in the High Court can be settled and a DMR can settle that case on behalf of the relevant person. And finally, a common trend is where there's a significant amount of assets standing to the credit of the relevant person, and the court will require a financial plan for those assets going forward. That's required under all Part 6 applications and is also required by most judges in Part 5 applications, and many applicants are not aware of the requirement for those financial plans. So there's a number of links set out in the slides there for various stakeholders who provide services in relation to assisted decision making, which may be of use to participants in the seminar. So that's my lot. Thank you very much.
Thank you, Peadar, for a very comprehensive overview of the legal aid element to this. So our next speaker now is Susie Byrne, who's the Regional Manager for the National Advocacy Service for People with Disabilities. And just before Susie speaks, I'm just going to remind all of our speakers again to try and keep to pause to enable our sign language interpreters, and also just to acknowledge the work of our panelists who are very busily answering questions as the presentation is happening simultaneously, so which is no mean feat. So I'm going to hand you over to Susie. Thank you very much.
Thanks very much, Caoimhe, for the invitation to speak today. My presentation, again, like the others, will focus primarily on decision-making representative orders and the role of advocacy in supporting relevant persons. The National Advocacy Service, for those of you who are not aware, is funded and supported by the Citizens Information Board and the Department of Social Protection. The Citizens Information Board have a statutory obligation to provide advocacy and a representative advocacy service for people with disabilities. We are a fully professional, independent, free and confidential service, and we have 50 paid professional staff across the country. We also launched and host the Patient Advocacy Service, which has been in operation since October 2019. Advocacy is not prescribed in the Assisted Decision Making Act, such as Peadar referred to, the relevant persons having their own legal representation. There's nothing in the Act that indicates that relevant persons should have advocacy, but it is recognised through the Decision Support Service Code of Practice, which outlines that independent advocacy is a professional support service provided by an organisation free from conflict of interest. and delivered, providing trained independent advocacy to give an understanding of the relevant person's will and preference, and support people to make a decision, and to indicate, if possible, their preference around those persons that are making applications to become decision-making representatives. So there is a code of practice around independent advocacy, and that is available for you to consult. The National Advocacy Service practice with regard to assisted decision-making and all the various parts of the Act, that has been fundamental to our organisation since its inception. Advocacy is a unique role. It is entirely person-led and directed. And I suppose it is underpinned by a key principle of the United Nations Convention on the Rights of Persons with Disabilities. And that people, who need support to exercise their autonomy should have access to the supports they require, like advocacy. Advocacy is accountable. All advocacy cases in NAS are reviewed and supervised by senior advocates and regional managers. We have a full suite of policies and code of practice to guide and direct the work, as well as the decision-making support service code of practice for independent advocates. We have continuing professional development and training through our training plan, and regular practice development for advocates, focusing on practice and sharing of examples and experience. In terms of the role of independent advocacy and the Act, we play a critical role in ensuring the relevant person's voice is heard and their rights and autonomy are upheld. Since the commencement of the Act, we have supported people to have information about their rights, to be viewed as decision makers, to have their voice heard with independent, impartial support, particularly where there are discharges from wardship being considered, in line with the guiding principles of the Act. And the guiding principles are very much to the core of NAS's practice. We support people to communicate with their legal representatives and to make their views directly known to the court regarding relevant matters. And these are all person-led methods of communication to the court in the form of letters to the court, but also support to attend proceedings in person or remotely where they wish to do so, and to seek the reasonable accommodations needed in order for this to happen. The advocacy process is outlined here, and where we receive inquiries with regard to relevant persons. These are either third-party or self-inquiries. They are allocated to an advocate to assess. The advocate will meet with the person, and the advocate will, if the person is eligible for the service and wishes to work with an advocate, make an advocacy plan with the person. The advocate will explain the circumstances of the inquiry that has been made to NAS and what the Assisted Decision Making Act is, and we will use various easy read, visual and other aids to explain this to the relevant persons. And we will also ensure, if the relevant person wishes, that independent legal assistance has been applied for. We will support relevant persons to participate in capacity assessments if required. And with the person's consent, we'll work in a number of ways, which I'll outline shortly, in order to gather information, including speaking with other people who know the person, maybe with speech and language therapists, with key workers, social workers, family members, in order to support us in our communication and ascertaining of the person's will and preference. We'll also support people in communication with their legal representatives to make their will and preference known with regard to the application that is being made, but also perhaps in relation to the applicants for the orders, and if the relevant persons are in agreement with the persons that are making the application, and so that their will and preference and their wishes can be communicated to the court. In terms of communicating the wishes to the court, we will support the persons with regard to writing a letter to the court, either them writing the letter directly or us writing a letter on their behalf with their instruction. And finally, as I've outlined, we support the person to attend court remotely or in person. And in terms of preparing for attendance, we might advise the court of any reasonable accommodations that are being sought in terms of a hearing earlier or later in the day, whether there is interpretation or other support required for the person to participate in the hearing. NAS has a number of models of advocacy practice specifically focusing on our remit to provide advocacy to people who communicate differently. So if somebody maybe has difficulty in communicating verbally, there are other ways in which we can ascertain their will and preference. And that includes using person-centered models that might engage in witness-observer pieces, speaking with other people who know the person, spending time with people where they live, maybe where they engage in activities during the day. We often meet people out in the communities where they live also to spend time with them, to make observations around their will and preference and how they express that. We use, of course, a rights-based approach at all times, and we also, of course, encompass the ordinary life principles. And where relevant, we will communicate our observations to the court in the form of a letter. In terms of assisted decision-making supports, they now make approximately 24% of all NAS work, and that can refer to specific supports under the Act, but also more generally in supporting people around expression of their will and preference around any decision that's to be made, not just those that are covered by the Assisted Decision-Making Act. I wanted to give you today an example of a case where a NAS advocate supported somebody for whom a decision-making representative order was being made. And this case concerns a woman named Hazel. Hazel acquired a brain injury in a workplace-related accident where she was unfortunately assaulted. During her hospital treatment and rehabilitation, clinicians raised the matter of decision-making supports, and an inquiry was made to NAS given the future decisions that were felt needed to be made at the time. And Hazel around that time was also moved to a nursing home for further rehabilitation. The NAS advocate supported Hazel to understand the process of seeking decision-making supports. And it became fairly clear that Hazel's first language was not English. And so the advocate supported Hazel to have appropriate communication supports and interpretation for both the capacity assessment and also for meetings with her legal aid board solicitor. During the course of the relationship that was being built between the advocate and Hazel, and this took place over many months, Hazel wanted to know more about the assault and what was going to happen in terms of the possible charges that were being made against the assailant. So the advocate made contact with the Gardaí to obtain more information. And the advocate also supported Hazel in terms of understanding information about personal injuries claims regarding the assault that may arise. And the advocate then wrote to the court to outline her wishes regarding her future, because Hazel had views about where she wanted to live and how she wanted to live in the future. And so these were conveyed to the court in the form of a letter. And also, I suppose, it was being considered an independent, it was determined that an independent decision-making representative be appointed. But at the hearing itself, Hazel did not want to attend in person, and so she was supported by her advocate to attend remotely, and the advocate went to the nursing home and attended the hearing remotely via laptop. The outcome was that a decision-making representative order was made and an independent panel representative was appointed. The advocate, following the order being made, with the consent of Hazel, briefed the panel member about the work that they'd undertaken with Hazel to date, particularly around accessing supports within the nursing home and the issue around the personal injuries matters. And that facilitated the decision-making representative to be better able to support and be aware of Hazel's support needs, communication needs, etc. In terms of how you can help support people to access advocacy in relation to matters to do with the Assisted Decision-Making Act and where you might be aware that decision-making representative orders are being considered, I would suggest that early inquiries are made to NAS regarding relevant persons. Time is needed to explore the inquiry and build the relationship with the person. There's also a role for advocacy in supporting relevant persons' wishes to be known to decision supporters after a decision-making representative order is made. And the code of practice, both for decision-making representatives and for independent advocates, covers the area where we might assist a decision-making representative in ascertaining the will and preference of the person following an order being made. And all of these relationships and advocacy casework takes time, so an early inquiry is encouraged to be made. We also, unfortunately, do have waiting lists in operation throughout the country, and so these will affect the availability of advocates to be able to support the voice and will and preference of the person. In terms of issues arising, I suppose there are many things that we observe in the course of our advocacy casework, and some of these have been referred to already, and particularly in terms of broad orders that have are being applied for. We would ask that people consider: are there actually decisions that need to be made, or are people more likely thinking, "Oh, we better get something made just in case it's needed in future"? That's not, I suppose, in the spirit of the guiding principles of the Act. Access to independent legal advice and assistance is really essential for relevant persons. What we often observe is applicants have made applications to the court. They don't understand why the relevant person might require their own legal advice. And this also applies to services where they might be making applications. And so we will encourage at all times that relevant persons have their own independent legal advice, not only for applications, but also for reviews. It is really important that people have access to advocacy to support their will and preference, because we are seeing courts asking for the person and why the person isn't being represented in court, why they're not attending court, and why they haven't been heard from. So it's again, I would encourage you to make early inquiries to NAS on behalf of relevant persons. We are also seeing an issue where there are notifiable parties listed in the Act, but they don't include many people who know people really well often, and that is service providers, key workers, registered providers of services. And this is definitely seen as an issue in terms of supporting the will and preference of the person where an application is being made, and that many people mightn't be aware that orders are being applied for, who could ensure that the will and preference of the relevant person is being heard in the application process and in court. We would ask, in terms of deciding on decision making, whether circles of support are more appropriate rather than consideration of orders under the Act, and that these are explored by families, by friends, and by service providers. There's a role for everybody involved in the process in supporting the voice of the person in court. While independent advocacy is essential, we also believe that applicants, the court service, and though others that support people have a role in supporting the voice and the will and preference of the person. And then I suppose I would draw people's attention again to the provision of relevant information that advocates can provide to decision makers when they have been appointed, in the form of a handover. The advocacy support generally ends on the appointment of decision-making representative, but there may be information to support the will and preference of the person that an advocate can provide when the order has been made. And again, I would remind you about the role of advocacy, and to consider the role of advocacy to support ascertaining the will and preference of somebody after a decision-making representation order has been made. Here you'll find information with regard to how to make inquiries to NAS. We have a phone line that is open between 10 a.m. and 4 p.m. Monday to Friday. You can find our inquiry forms online on advocacy.ie. And you can also send emails to info@advocacy.ie to have copies of the inquiry forms sent to you. Thank you very much.
Thank you, Susie. That was excellent. And just to reiterate a number of things, we've numbers of questions from people about will the recording be made available? Will the slides be made available at the end of the webinar? Yes, they will be. The recording will be hosted on our YouTube channel, so there'll be an email sent to all participants with details of where the recording can be accessed and also information in relation to the slides as well, and the transcript of the questions as well is also made available, because as you can see, we've many questions that have been already answered during so far in the last hour. The other thing I want to mention as well is there will be an additional recording with Judge John O'Connor, which will attach onto this one as well. Judge O'Connor has actually answered many of the questions actually that we had in the chat in relation to some of the specifics in terms of how cases are run in his court, which is the Dublin Circuit Court. Just a couple of other things then. If you are interested in a certificate of attendance, there will be a QR code put up into the chat at the end of the webinar. So if you can hold on for that, and if you have any difficulties accessing that, please do email us at adm@hse.ie. And then there might be people on the webinar who have not signed up to our newsletter. So also there'll be information in the chat function in terms of how to sign up to our newsletter, because you'll get information about our next series, or the next one of this series, which will take place in September. We're just finalising the topic for that at the moment. So we're going to now go to Ultan Hines, who manages the Nursing Home Support Scheme. And Ultan, this is a recording, but Ultan will join us live for the questions section. So over to Ultan Hines. Thank you.
Hi, my name is Ultan Hines from the Nursing Home Support Scheme National Office, and I am talking today on ADM and its impact on the Nursing Home Support Scheme. So we'll just have a quick look at what NHSS actually is. We'll talk about the key changes under the Assisted Decision Making Capacity Act 2015. We look at who can make an application for Fair Deal. When is a DMRO required for NHSS? Where to get NHSS information on the DMRO process that specifically relates to Fair Deal application. We'll look at the application form and also where there is a significant level of support on the HSE website. And also then we'll look at some further relevant contact information. So Fair Deal, or the Nursing Home Support Scheme, is a scheme of financial support to clients deemed to require long-term residential care. It's run under the Nursing Home Support Scheme Act 2009 requirements. Currently, there's 24,200 clients being supported. We've one national awaiting funding list, and funding is issued weekly in strict chronological order, 4 weeks awaiting funding time. The average length of stay is 3 years, and we've annual funding in excess of 1.3 billion euros. So it's a co-funded scheme, and that means that both the HSE and the client make a contribution. The contribution is made directly to the nursing home. The nursing home is chosen by the applicant and money follows the resident. So the nursing home decides which nursing home they wish to go to. They pay their client contribution and we pay state support on their behalf to that nursing home. Okay, so in terms of applying for Fair Deal, then there is a Fair Deal application form, and there are 4 parts to that application process. So there's a care needs assessment application, and that is to decide under the NHSS Act 2009 as to whether a person does or does not require long-term residential care. If they do, then they can apply for state support, and that is the funding that the HSE will pay on their behalf. And that funding plus their client contribution makes up the weekly cost of care at their desired nursing home. They also have the option to apply for ancillary state support, which is known as the nursing home loan. So this is optional, and this is an area where the state will pay part of your client contribution related to property. The majority of DMRO applications currently are being driven by a requirement for an application for ancillary state support. And we'd also always recommend that people apply for ASS if there's any sense that they may need to avail of it when they're applying for state support. There's also a number of other features, including 3-year cap on family farms and businesses. And again, this is an optional 3-year cap benefit. And this is of huge benefit to a small number of people. But again, there may be a requirement to apply for a decision-making representation order if that application is going through and the person doesn't have the capacity to approve that application. So all applications should be forwarded to the local nursing home support office, and details of those offices are available on the NHSS application form and on the HSE website. Okay, so just to recap then, what has changed. So a care representative is no longer appointed by the courts, and a DMRO to include specific powers in respect of NHSS must be secured. The following can act as a specified person, and a specified person can act when an applicant doesn't have the capacity to make an application and they wish to apply for state support only. In that case, one of the following, that's the applicant's spouse or partner, their children of over 18, registered medical practitioner, nurse or social worker can make an application on their behalf. The specified person's roles and responsibility has also changed. They have very serious obligations under the NHSS Act, and Section 46A principles with regard to specified persons should be noted by anybody taking on that role. Okay, so who can apply for Fair Deal? Well, the applicant themselves, and they should always apply if they have the capacity to do so. It may well be that a social worker, public health nurse, or a family member indeed could be assisting a person with huge level of assistance in terms of completing the application. But the application is under the control of the person themselves. They have the right, and they're the only person who can submit that application, and they can also withdraw it at any time. If the applicant doesn't have capacity, well, if it's for state support, as I mentioned, the specified person can make an application on their behalf, or a person who is legally appointed to act, and that could be an attorney under an enduring power of attorney, a DMR, or a committee of ward or court, and we still have a small number of wardship arrangements in place. So just to reiterate, the person themselves makes the application unless they are unable to do so, and in that case, only a person with the legal authority to do so can make the application on their behalf. Okay, so let's just break down then when a DMRO might be required for a nursing home support scheme application. So in the case of state support only, if the applicant doesn't have the capacity to apply and there is no specified person available to act. Now this occurs in a very, very, very small number of cases. It is most unusual. There is normally a specified person available to act if a state support only application is being made. For ancillary state support then, if the applicant or another member of a couple doesn't have the capacity to authorise the HSE to complete the approval process, it will be necessary to secure a DMRO with the relevant authority detailed within that to allow the HSE to take instruction. And again, 3-year cap benefit on family farms and businesses, it's the same situation. Again, there may be a requirement if the person or a spouse partner is unable to provide authorisation to HSE to complete the process. While not directly related to the NHSS application itself, but there is that whole issue of the management of the nursing home support scheme clients' financial assets. And it should be considered very seriously in any DMRO application. And this has got to do with accessing bank accounts, making payments, managing assets, and also we look later at signing a contract of care. So not directly related to getting an NHSS application to a decision on funding approval, but when one is making an application for a decision-making representation order, it's important that the whole range of services or powers that a person may need to support the applicant, to support the person in a nursing home are considered at that time. Okay, so I said the application is made on a nursing home support scheme application form, and it's both an application form and a support information document. So it's quite a long document. We would ask people to read the document in detail before they start filling it out. There's a lot of information out front which assists you in understanding what we're looking for and where it can be got in terms of bank details, financial details, asset details, etc. And it can be got from the HSE website. It can be downloaded. Nursing home support office can provide them, and also acute hospitals and community care offices will have application forms as well. So again, there are 7-page sections to the application. So everybody will fill out section 1 to 4. And if the application is for state support only, you'll only be filling out section 1 to 4. So 18%, as in 18% of applicants are supported with ancillary state support. So less than 1 in 5 applicants will need to apply for ASS. And just to reiterate again, if anybody is considering that they may need ASS, they should apply for it. They don't have to accept it. We can offer them ASS. They don't have to accept. They can tell us at any stage to stop processing that element. All right. There are specific requirements, approvals required within the document. So for instance, if we look at section 2B, This is an application for a care needs assessment. So basically, the same application you apply for the care needs assessment and state support, you sign twice. It's all done in the same process. So either the person is applying or a person with legal authority to act, and they're listed there as I make this application as, so it's either spouse, partner, or specified person, or else a person with legal authority. And you need to state which that is, and then you'll also be required to provide a copy, for instance, if it is a decision-making representative, to provide a copy of the court order for us to confirm that you are authorised to do so and that you have the specific authorisations within the order to act supporting the person with their fair deal application. Okay, so the HSE website also contains a significant level of detail on generally the application process, what's required, what's available from Fair Deal, but specifically on applying for a decision-making representation order. And I'm just going to show you just some of the snips from the application. So within this section here on the application, get appointed as a DMR. So we've provided a lot of detail here. And again, if you want to click on these boxes here on the website, it'll give you a good understanding of what we require and what we recommend should be included in DMR documentation that's going to the court. So we have recommended text. This is suggested text relevant to NHSS, and this can be copied and pasted into the application to the courts. The courts are aware of this text. It's familiar to them. And if this text is used, it means that there can be no question over the DMR's authority to act on behalf of the person in respect of a fair deal application. Now, this level of text isn't required, but if it's used, there is no question. Unfortunately, if a person comes with a decision-making representation order and that order is not sufficient for us to take their instruction to act under the Act, they will have to go back to court to get that corrected. So this is, I suppose, what we're offering really here is a foolproof option for people to use this text and to make sure that they will have the authority to act under fair deal. Doesn't have to be used, but you know, it's there to be copied and pasted. So the decision-making representative, generally, they may complete and submit an NHSS application form. And that could include taking charge of an already submitted state support application form by a specified person. So it wouldn't be unusual for, say, a medical social worker to have started a state support application. Then it's understood that ASS is required and a DMR will be appointed. At that point, the DMR will take full responsibility for the application and there will be a handover of the details, etc. That person would need, the DMR will need to liaise with the Nursing Home Support Office to complete that application process, and the NHSO will be happy to support them on that. They will need to review the NHSS decision on entitlement to support under the Act and the calculation of weekly client contribution, and they have the authority to appeal under the Act, and that's a statutory appeal, and a statutory independent appeals officer within the HSE reviews those cases. So again, when a decision is made by the HSE for NHSS, the details of the appeals officer and how one appeals is provided in that, and then that goes separately from us into the appeals process, and a decision is made at that point. So post NHSS application decisions then, so just because we've approved fair deal, there may still be work to be done. So for instance, the HSE needs to be advised of any material change in circumstances. So that would include significant changes in income, assets, relevant events, death of a partner. For instance, we come across a case where people in nursing homes will inherit estates or inherit funding, etc., properties from their brothers or sisters. The DMR may have the authority, for instance, to sell a property, at which point they will need to involve the Nursing Home Support Office because there will be a change in financial calculation at that point. The applicant and now the DMR has a right to seek financial reassessment after 12 months. So if the applicant's bank funding is being used to pay their client contribution, for instance, their financial assets will be reduced, and on production of a bank statement to show that, we will then undertake a revised financial assessment, and realistically that will reduce the weekly client contribution for the applicant. So that's a task that is clearly to the benefit of the applicant. And you know, we continue to make decisions. For instance, at the end of 3 years, we removed the 3-year cap. The DMR will have the right to make an appeal against any of those decisions as well. So just, I suppose, the entitlement to act then. So the DMRO, just to reiterate, it must include authority to act on NHSS issues, and it must be specific. So that's why I say we have the suggested text on the website. If it's used, there is no question over the DMR's authority. If it's not used, we can probably still work, but we're really trying not to have a situation where a DMR has to go back to court. That's in nobody's interest. So a usable text is available to those people. I suppose just a few points of note as well. NHSS approval does not mean the applicant can be admitted to a nursing home. That's a separate issue. It is a scheme of financial support only. And again, I call it the contract of care. So be aware that the contract of care will be required to be considered and signed at the point at which a person is entering a nursing home. Again, it's separate to the NHS approval process, but it is an important document and it should be considered fully before being signed. So to understand any extra charges, arrangements over disputes, etc., it's very important that document is reviewed. Social charges may be levied by private nursing homes, and these are not funded under NHSS. Again, they would be listed in the contract of care. So further information then, so the HSE website, the NHSS pages, they're updated for assisted decision making, and the new application form is available there as well. The NHSS application form has a step-by-step guide to completing the application process. HSE Live are available as well to direct people where to get extra information. And obviously the Nursing Home Support Office then, they make decisions on the applications. So there are 17 of those across the country. And, you know, when a person is submitting an application, they'll be dealing with their local office. And if there are issues, etc., the NHSO will be able to assist anyone, a DMR or anyone else dealing with the case. Obviously the court service and the decision support service contact details are there as well. Thank you.
Thank you, Ultan. I know Ultan now has joined us live for the questions which will be coming up quite soon. So our final speaker is Sarah Whelan. And Sarah is a panel decision-making representative. So we thought it would be really helpful to hear what panel decision-making representatives do and don't do. And I know there's a question, one of the questions came in about what's the role and scope. So I think Sarah is going to talk to us about that as well. Just to say again, there's a lot of very complex information that's been addressed here, so the recording will be very important for any of you that are dealing with these directly. If you want to come back and I suppose refresh yourself in terms of the various elements, depending on the kind of people that you're supporting, or if you're indeed supporting a family member through this process as well. So Sarah, we're going to take Sarah's presentation and then we'll open it up to the panel then for some additional questions. Thank you.
Thank you, everybody. My name is Sarah Whelan. I'm one of the aforementioned panel DMRs, and I suppose in putting this together today, I was trying to think of some of the frequently asked questions of a panel DMR and some of the issues that have come up for me in the last 3 years of working as a panel DMR. And just to say at the outset that the appointments that I've had have been from both the Circuit and the High Court, and there's been, I suppose, a great range in the type of work that's come from that and in the relevant persons that I have been working to support. What I will say is that I myself am a social worker, and I know there are many of us within the panel DMR and the DSS panel DMR, and I think that's probably a growing number. So what I want to say at the outset is, just in getting started, some of the very obvious things, I suppose, if you're a panel DMR on appointment, is that you, when you agree to have your name put forward for nomination to the court, really all you will know is the person's name and the person's address. So when you go to the court hearing, either in person or as part of an online attendance, that's your first opportunity really to hear a little bit about the person. And following the hearing, you'll receive the documents really that were part of that application. So one of the things that's really obvious to me as a DMR in the first instance, that you will often see very significant gaps in the person's life story and in their history. And so that is relevant really, you know, at a later on point when you're taking up the work, because really when you're putting your focus on the will and preference of a person, you will need to go back and look and get into the information gathering and do the 360 really, because the way I describe it to people is that the DMR is really on a catch up in a person's life. Your name is on the order. You have these tasks to complete, but the person is not known to you. So what you have to do in that instance is measure the kind of the expectation and the realities that come with that. So a little bit about unpicking the role. So I know that Anya will have mentioned this a good bit earlier about, all DMOs are obviously we're a broad church of people coming in together into this role, but people are informed by their own professional training and their own code of ethics. None of us are a blank slate coming into the work, and you don't set that aside when you begin the work. However, you very clearly have to highlight the distinction between being a DMO and, for me, for example, being an MDT or having a clinical role in supporting the person. So, I think it's very helpful to invite questions at the very beginning for the people that you're working with, be it the relevant person or the support people around the person, or the formal, if there are the frontline staff that you're working with, that to invite questions on what the boundaries might be and what the specific tasks that are going to be attributed to you as the DMO. And always recognizing at the outset that you do want to be intervening at the lowest level in the relevant person's life. So for me, that really means that if I'm meeting somebody and I see really robust, good, workable systems in place that really respect the person's will and preference, that's absolutely fantastic. There's no need for me to be overriding any of that. So I would always name with the service or with the person, what would be the point of contact, what would be the expected frequency of the contact, so that you're very clear on what people's expectations are. It's my aim to be responsive, but I'm not on call. I tend to find that most of the contact I have is via email, and that it works very well. So obviously, as I said, not knowing the person in the initial steps, you really are going to have a collaborative approach. But that means that, there are times that I would need to know when to ask a lot of questions and to ask why. And I'm also quite confident in saying at times no to something where I don't feel it's appropriate or part of my role. You would have to absolutely acknowledge as a DMO that this is a newer role in healthcare settings, and it's very helpful at the outset to have that conversation with people that you're working with. People might say to me, I'm not quite sure what to expect of you, or what will you be doing? And that's fine too. So I know that there was discussion earlier about the orders and how the orders can look different depending on where the order comes from and the court that it comes from. So some of the High Court orders have a more general authority, and the Circuit Court orders might be more almost lists of tasks to be completed. I mention this because I suppose when you're going somewhere with an order and you're presenting the order and you're the DMO, and you're going to be the person named on the order, I do find that agencies can expect orders to follow a format, and it's not uncommon for somebody to say, oh, this doesn't look anything like the last order I saw. So that can take a little bit of explanation. We talk a lot, I suppose, in ADM really about the spirit of the Act, the principles of the Act. But it's been my experience as a DMO that once you're operating from an order, it is a very literal interpretation of that order. And so you can't find yourself in a discussion about the wording, the order of the words in a sentence and what that might mean for a financial institution or for a pension provider. And certainly I would have had a situation where a banking institution and the payer of the pension took opposing positions on the wording of the order, which wasn't that straightforward. So in talking about the order, what I will say that it's really important to recognize and to name the authority in the order, but also there are limits in the order, and there are no add-ons to the order. The order is as is written in the text. The reviews, as mentioned earlier, the reviews are DMO led. You might be working in a position where you're asked as a clinician or working in the front line or within a hospital setting to complete a capacity assessment. And certainly, I think in the next couple of years, DMOs will be really doing that, following discharges from the High Court. But it is a significant piece of work for a DMO to source the capacity assessment, write the affidavit. You might be providing additional exhibits, the original capacity assessment, serving the relevant person the documents on them, stamping, going to the court office, and then attending the hearing. There's been mention earlier also of the need for DMRs to vary orders, and that certainly has arisen for me in my time. And what I will say about that, it's an easy sentence to say, vary an order. There is a job of work on it. It can be difficult to return to a lower court with a high court order and have that varied. And, maybe less so for a circuit court order. This slide really is just speaking to the role and to the work of a DMR. And I suppose those 4 different graphics there really refer to the different competing pieces of work that are ongoing. So there are always going to be priorities. The priorities are going to have to be planned. There are reporting back to the DSS, the statutory reporting, and there will be reviews. So really, you're going to have to decide if you're working with the DMR or you are a DMR yourself, who's going to decide what is time sensitive. You're always going to need to be looking at the will and preference and how you're going to incorporate that into the body of the work. And that should be a rolling item on any agenda really for a DMR. You will have to work to the order, and that the order, you can't set aside anything that's in an order. And your statutory obligations are there in that regard. The reporting, I know that Anya mentioned it earlier, there's an initial report, an annual report, they need to be completed. And I suppose the DMR, in planning their schedule of work for a year, will have to decide what is the order in which you undertake different tasks. I do think it's important to say with regard to this role that you do need to be fairly self-motivated and into problem solving, because certainly there will be bumps along the road. Will and preference, I know that Susie mentioned this earlier, and it's a very strong part of the work of an advocate. And certainly for a DMR, the question for me with regard to will and preference is, where is it recorded? When does this date from? With whom? Where, and what is the mechanism for constantly reviewing those pieces of a person's life? So it really has to be a collaborative piece. So for me, I'm really looking at the person's communication and their decision-making profile. I find it quite straightforward really to start with that if you're looking for indicators of the relevant person's preferences in their daily decision-making. So you can see a lot about a person's independence, their likes, their dislikes, the people they want to be with, the people they don't want to be with, the things they like to buy, the things they like to, places they like to go. You can actually determine a lot about a person. And as I said, it's a rolling agenda item. It should be referred to, I believe, in an affidavit when you're going back to court, that you can evidence to the court in a review that actually you've considered that as part of your work when you're updating the court as part of a capacity review. I've picked this case example today because I think it was something that I didn't expect. It's quite a straightforward thing, but the relevant person, an 84-year-old, an advanced dementia, lives alone, quite physically well, one family member who visits, and a home care package in place twice daily. When I was attending this hearing, I suppose in the first 10 minutes, I really felt that this case was going to result in an order for a nursing home support scheme. And I was entirely wrong, because the will and preference of this person was to remain at home. And the circuit court order here really reflected the DMR authority to support that. So it really is about a collaborative approach to support the formal and the informal supports to keep that person at home, and to kind of provide a structure to that, and to give authority to the DMR to set up the necessary payments, the supports, what is to be purchased, what does the person really need to scaffold them safely in their home. So there are clear risks in a case like that. And I wonder if that person became unwell and they went into hospital, would there be very different debates? But at this time, the supports that are in place are working well. And I think as a DMR, and I would include the MDT, the primary care physicians that support that gentleman, that people are holding the line on that rather than being risk averse. So just a little bit about the challenges. It is a challenge as a DMR to accept a nomination with very little information about the relevant person. And I know that the DSS really doesn't receive very much information about the person. It's difficult in that sense to predict the volume of the work. And really a DMR, in the first instance, the work can be very front-loaded in the initial period. So it can be difficult to predict the volume of the work if you have very little information. It is a challenge to work where the relevant person doesn't accept the order or accept the need for a DMR. And that was probably something I didn't anticipate. It can be a challenge where there are additional proceedings. It's decided that additional proceedings are necessary, and the DMR can now be in the position of being a respondent and in the shoes of the relevant person in those proceedings. I mentioned earlier varying orders. It certainly is a skill set. It's a fast learning curve. It is absolutely a part of the work, but it is onerous. Lastly, just to say that I know a number of people said to me in reviewing the orders, I was very surprised to see the address of the DMR on the order. And I suppose most of us within the health service would not be used to that, to having our home address maybe published, and maybe that flies a little bit in the face of talking about boundaries, but that's as it is. Lastly, I just want to talk about the champions along the way. Certainly it's been a huge learning for me in the last couple of years. And I really think that it's worth calling out things that have gone well and where the support has come from along the way. So certainly colleagues across the health service have been an enormous support and are, I would say, generally really supportive of the DMO role. I find public servants are so helpful. I nearly have a hotline to various government departments at this point and have been able to build up a relationship with people, and they're just really helpful. I think the DSS information campaign has really, you can really see that is bearing fruit, and people are much more tuned in to the information and to the guiding principles. For myself, I think it's been critical to have a DMO peer support group and to have a lot of informal conversations with other DMOs and to have a more formal support group set up where really we're committed to discussing where we might find ourselves in a cul-de-sac and how do we navigate out of that. Certainly the ADMC help desk in Dublin Circuit, absolutely a wonderful resource for panel DMOs, non-panel DMOs, the general public, so committed to helping people to navigate through that system. Court registrars, again, very helpful. And the Legal Aid Board, really no question is ever rejected from the Legal Aid Board. They will do make every effort to answer a question for you. And as a non-legal DMO, I have found it really helpful to ask a lot of ABC questions from colleagues in the legal profession. And I suppose I mention all of these because what I want to say is that all of this is demonstrating a commitment to sharing the learning, which has been absolutely invaluable. And that's me. Thank you.
Thank you, Sarah. That was really helpful. I think it's really important for people to hear what it's like to be a panel DMO. So can I ask all of our panelists to turn on your cameras now? We have about 10 minutes for questions. This webinar is a little bit longer because we've a much bigger panel and because of the complexity of detail. I think we're nearly at the 100 mark in terms of questions that have been answered during the presentation, which is quite exceptional. So I'm going to go directly, and these are questions, some of which have been partially answered and others not at all. So just bear with me. This is a question for all of the panelists, and I might start with Ultan actually on this one. So what resources are available for lay litigants, for people trying to undertake the DMR applications themselves that can't necessarily afford, that don't qualify for legal aid, but maybe can't afford to have a solicitor. So what resources are available in the community to support people to do that? So ultimately, we might go to you first, okay, then Peadar, then Anya, and then Susie as well. Thank you.
So in respect of the NHSS element of an application for a DMRO, as I said in the webinar earlier on, I mean, go to the HSE website and look at that section, and the text is there. And if you use that text, the DMO role will be suitable for whichever element of NHSS you need to apply for. So that's probably our primary support for people, and that would be their first point of contact as far as I'm concerned.
Okay, is that Jacqueline? I wonder, is that information available in the chat function? Maybe if we can make the link available there, that would be really helpful. So Peadar, what supports are available to people that say don't qualify for legal aid but can't afford a solicitor? So is there anything else available to them? Are there centres that they can go to for advice?
There are, but in terms of somebody who doesn't qualify for legal aid when having applied to the Legal Aid Board, they are entitled to make an application for a waiver of any contribution. So the fact that they don't qualify initially is not necessarily the end of their application to the Legal Aid Board. So I would encourage anybody who is constrained means to make an application for a waiver, and they may well be successful and be able to be entitled to legal aid. Then outside the Legal Aid Board, there are numerous community law centres in various communities around the country and the city. Local to ourselves, there's Northside Community Law Centre and Ballymun Community Law Centre, and they wouldn't have that means test that the Legal Aid Board applies. So there may well be advice available and assistance available to applicants from those community law centres. Other than that, I find, and anecdotally you can say, that the staff in the court service office have been very, very helpful in assisting applicants in completing the application forms.
Okay, and Peadar, just off the top of your head, what proportion of applications in the Dublin Circuit Court, because Dublin Circuit Court is the busiest court, are from people without legal representation? So the applicant themselves, roughly.
I would estimate somewhere around 30%. It's quite high.
Which is high, which is very high. Yeah. Okay. Super. Okay. Thank you. Anya, I might go to yourself in terms of what resources are available. I know some of that is in the chat, but I think it's good to reiterate it again for people.
Yeah, and some of the links in my own presentation will take you directly to the court service resources about bringing an application, whether it's on the theme of potentially needing a DMR to bring a fair deal application or anything else. Also on our own resources page and services on the website, yeah, we have tiles that will take you straight through to the decision-making representation order and the lower tiers of support. Just reminding people, I know everyone here probably knows that we don't process or manage those applications in any way. So our guidance is kind of gleaned from other people's guidance and our sense of what would assist when you're making your way to the court, and the good stuff about the guiding principles and so on, and how you go there as a last resort.
Okay. Thank you, Anya. And then Susie, and I think Susie as well, if there are other resources outside of NAS and other advocacy organizations or other supports, if you can maybe flag those as well, maybe other community organizations that do support individuals, that would be helpful.
In terms of relevant persons, I know that information has been made available, in easy read format by the Decision Support Service. I'd also encourage people to look at the NAS website in relation to leaflets that explore what advocacy is, that are available in easy reading. There's also a My Money and Me leaflet that we've developed to support people, particularly maybe where decision-making representative orders mightn't be required. It would also to consider whether people and how people make decisions about what they spend their money on, and whether they might want a decision-making assistant or a co-decision maker, and to consider that also. There's probably a need to develop more information for relevant persons in relation to the Act, for all aspects of the Act, including the Advanced Healthcare Directives, and from the perspective of disabled people themselves. And I know that the Decision Support Service have worked with other organisations and advocacy champions to develop information, but I would probably say that in our experience that more information is better than what we have at the moment, that there's a need for developing that in the future.
Super. Okay, so in our remaining time, there's been a number of questions about, and this is probably for Pather and Susie. So the person has a legal aid solicitor, the relevant person has a legal aid solicitor. Do they need an advocate? So in some courts, they need an advocate as well. In some courts, they don't need an advocate as well. And I think people are conscious that NAS have a waiting list, SAGE have a waiting list, that there's not enough advocates for the number of cases. So Pather, I suppose, what are you seeing in the Dublin Circuit Court? And then Susie, then, like, what's your guidance in terms of like what should people do? And I suppose just the other thing to say is that I asked this direct question to Judge O'Connor yesterday, so he gives a piece on it, so that is in the webinar or the recording that'll be made available when this is all released to people. So Pather first.
Two ways of looking at this. The Act, just like it doesn't prescribe that a relevant person should have an independent solicitor, it doesn't prescribe that it should be an advocate. But what it does prescribe is that the hearing shall be heard in the presence of the relevant person. And when the relevant person is unable to attend, the court will accept a report from an advocate as representing the voice of the relevant person to satisfy Section 139. So whenever a relevant person is unable to attend court, either in person or remotely, the court will require an advocate's report. Usually then, if the relevant person is aged and above the age of 65, that's SAGE advocacy. For relevant persons who might have acquired brain injuries or other issues, it's the National Advocacy Service. In every case where the relevant person is not attending court, the court will insist on an advocate's report. Now, when I say every, there have been one or two rare occasions where the court has accepted the Legal Aid Board solicitor's report, but would have directed that it was conducted in such a way as to try and acquire the voice as well. The court considers that the solicitor and the advocate have very different skill sets and can elicit different information from the relevant person. The other aspect of this is that an advocate, certain persons will require an advocate not to satisfy the requirement of the Act, but simply because of their circumstances. And that's outside the remit, I think, of the court or the Legal Aid Board to determine whether or not a person needs an advocate for reasons other than to satisfy the provision of Section 139.
Great. Thank you, Pather. And Susie?
I'm going to talk outside of the court because advocacy is not covered by the Act. And I'm going to say, first of all, I think that inquiries should be submitted to NAS regarding anybody, either by themselves or, by people who believe that they may benefit from advocacy support. If it is, in terms of meeting with the person, if the person is very clear in relation to their will and preference and doesn't want to work with us or may not have an additional benefit from our support, then we won't proceed. But I think it's probably better to err in terms of ensuring that somebody has access to advocacy where orders are being considered. So that we can support them in communication with their legal professional, but also to make their will and preference known, and also to seek those reasonable accommodations, perhaps that that would assist their participation in the court process.
Great. We're running out of time now, but I have a couple more burning questions. Numbers of questions about what protections are in place when there's a complaints process. So what protections are in place for the relevant person when there is a complaint in being about the decision-making representative. So if Anya and colleagues could address that one.
Is that apprehending a certain active risk to the relevant person?
Yes. So where there's concerns about the decision-making representative, that has been escalated through the complaints process. How might the relevant person be protected then while the complaints process is ongoing?
I touched on it briefly, but in the most acute cases, and the bar is quite high, where there's an active risk and a perception of harm, then we can apply for a temporary prohibition order from the court while the investigation is still pending. We've had occasion to do that only once, in order to ensure the protection of the relevant person from the DMR who had been selected. Patsy may want to come in, but we also have policies around escalating to safeguarding or to the guards, sometimes in the worst cases where we apprehend that that's the thing to go and that we're looking at an allegation which goes as far as being criminal in nature. Patsy, I don't know if there's anything you want to add there.
No, thanks, Sonia. Just to say perhaps that we would also engage with the advocacy agencies and the National Advocacy Service. If the person didn't actually have an advocate, we would ask for one to be appointed perhaps as well, in addition to what you mentioned, Anya.
Okay. Peadar, you may or may not be able to answer this, but there's some questions about the court vacation.
Yeah.
Does the court take like I know in previous years there have been hearings in September. Are you aware whether that will happen this year?
I haven't seen it formally written anywhere, but I have heard that there will be sittings 2 dates in September as there were last year.
Okay.
So there'll be that gap between the 31st of July and I think the 3rd of October, but there will be
Okay.
2 weeks set aside for hearings.
And for people that are on the webinar now, if they haven't been given those dates, should they go to court to seek whether they can be part of the September hearing?
Yes, is my
Okay.
short.
Okay, in short, yeah. Okay. Just one very last question then for Sarah. Sarah, like there's a couple of questions then from like what kind of information should be made available from, let's say, care homes to a decision-making representative? Let's say you've just been appointed as a decision-making representative, and what kinds of information would be helpful for a panel decision-making representative when someone is, let's say, in residential care?
Where somebody's already a resident, is it? Sorry, can you hear me?
Yes,
is that when a person is already a resident? Well, certainly for me,
right,
I'd be looking at a kind of a 360 of the person, really, in terms of their daily life, the choices, their everyday decision making, the options they have, the choices they have, the governance around their money, the options to do something different, the options to not do something, just generally the options around what's there and what is working well for the person, and what are the things that might need attention, or if there are concerns. You know, it would be kind of a 360 really, I would think, and also while looking at the order.
Great, that's super. Okay, so we still have 18 other questions in our question function. So I think this is probably, we've topped out in terms of the numbers of questions that we've received for this webinar. So we will be putting together, as we do for all webinars, a question and answer sheet so that people have that available afterwards, because I think the level of detail that all of the panelists and all of the panelists that weren't speaking live have given today is very rich, and I think is very important that you have as a reference. So I'd just like to thank everyone for, so obviously there's the time that people have given now, but there's a lot of work that people have to put in terms of the presentation. So we really appreciate that. And also the time people have given beforehand. I'd like to thank Tom and our own team in terms of all of the prep that's required for all of these webinars, and our two sign language interpreters. Thank you so much again to Lisa and Romy for your work today. We are planning a series of webinars for the autumn. We're just in the process of coming up with which topics. There's many competing ones that we're trying to decide on at the moment, but we'll have information out to you before the summer kind of properly kicks off in relation to that. I think that's all of mine. So again, as I said earlier on, the QR code, I believe, is going to be shared now, or has been shared. We will make all of the presentations available with the recording link. And again, as I said earlier, there will be an additional recording with Judge John O'Connor, who talks about the experience as a judge in the Dublin Circuit Court in particular. If you have any feedback or questions in relation to any of the issues raised today, just contact us directly and we can send it to the various speakers that have joined us today, or contact them directly. They've shared their details. So thanks everybody. Thanks for your time, and we'll see you all in September. Thank you.